Hey, Brian, you gonna take pictures? You guys want some pictures? Oh, okay. Well, we can get some preliminary pictures before we get started. Okay. How about in front of the UN flag?
UN flag.
Brian will. This is Brian. Brian's all of our conferences.
Oh, okay.
Do you like this room? Yeah?
I do.
So it's like
I feel like it used to be bigger.
No, it's the same size. Hey, how are you? Okay. Okay. No, it's the same size. What we did is we added the technology,
Okay.
shrank down that technology, put the little things at every desk, all new lighting, the portraits on the walls, the back carpet. Kind of spruced it up. Oh, we expanded. This part was just three people could sit there, and we had all these conferences where we weren't using it. We were sitting down here because we couldn't fit it up. So we built these out in 2 weeks, and then the
Like a little
jury's
box.
the jury's box used to just be like a metal bar, and now we have it like so. Got our 200,000.
Yeah, that's great.
So I have to sneak out halfway through the presentation. And tomorrow you'll be there. The whole thing.
Yeah, of course.
And then I'll do a full introduction of you tomorrow. Today, as I said, Abinant Professor Cover will be introducing you. I'll just kind of talk to every person for 5 minutes. And then you guys are at dinner or
we're actually going to see Fun Home.
Oh yeah.
At
Let me
a
give you a
place.
warning. It's not a fun musical.
Yeah.
It's a really depressing, serious
Okay.
musical.
So it's a misnomer.
The name is really misleading. I saw it on Broadway with my son.
Did you like it?
It was powerful. It made me think.
Okay.
But it was sort of like, did you ever see Angels in America?
I did not know.
It's like one of those really, really depressive, powerful musicals. But it's not one where you'll leave humming to.
Okay.
Not like Hamilton. Have you seen that, by the way? You have to see Hamilton. Yeah. That is like the world's best musical ever.
Okay.
Yeah. Ever.
Good to know.
Yeah,
I haven't even heard of it.
oh, you hadn't heard of it? Oh, where have you been?
I don't know.
So it's in New York. It's been there for a year. It won 15 Tony Awards, the world's record.
Wow.
Yep.
Okay.
And it's the story of Alexander Hamilton. It's a music. It's rap, hip hop, and regular music.
Okay.
And it is so novel, different than anything else. And plus, it's got a great story. There he is. Avi, take your
Hi, I'm Nate.
This is Nate.
Avi, great to meet you. So glad.
Take your pen out so we can have pictures of you.
Fair enough. You don't think that would be a good look?
So I'm going to just do a general welcome, turn it over to you, and then after 15 minutes or so, I have to sneak out.
Okay.
So,
Understood.
yeah.
Understood.
Okay.
All right. Great.
Avi runs our Institute for Global Security Law and Policy.
Okay.
So
Great.
everybody knows all the best programs in this.
All right.
Do a lot of
Right,
I
well,
can't.
I officially snatched this from you, right? So,
Yeah.
There you go.
Oh, Brian, so can you take a picture of the three of us with the UN flag behind us? How do you want to? Yeah, that's good. Do you get the UN flag? Have you ever met Jim Johnson?
Yes. Yeah, we do.
You don't.
So when did you get here?
I've actually been traveling around. I went to Montreal first, and then I came to Cleveland, visited my family. For a couple of weeks. My family is from here, and I grew up in Angola.
Okay, ready?
And then came back to France.
All right, let's do it on 3. 1, 2, 3.
Okay.
And just do it. All right. 1, 2, 3.
Okay.
All right.
And Jim, do you want one with?
Well, we'll do it right after Jack.
So you'll do it. Are you going to be here the whole time, or are you going to leave after a while? Okay, so Jim was Nate's former boss, and he's an adjunct professor, teaches war crimes. And then there's a couple of people from the tribunals that are coming in to see Nate speak. So maybe afterwards, grab. Are we doing a reception too? Oh, okay. There's a reception too.
Oh, okay.
So-
Okay.
All right. All right. This is up at your height. We don't really use the. I don't think we have. Never seen that work. What's that?
I'm just checking in.
Oh, okay. We'll wait 2 more minutes and then we'll get started.
Where do you want me to stand?
No, just have to stand over here and then I'll bring you.
Jump out.
I assume you went over this, but.
Oh, okay.
I guess about 40. Yeah.
All right, good afternoon, everybody. Welcome, thank you. For those of you who don't know me, I'm Michael Scharf. I'm the co-dean of the law school, and as often is the case, it is my privilege to give a dean's welcome and kick things off for a really special lecture. Now, the Cox International Law Center, together with the International Institute for Global Security, Law, and Policy, have often co-sponsored events, and some of those events have been the best that the law school has ever seen. And so, once again, it's really a pleasure to be partnering with Professor Avedon Cover, who will be introducing the speaker today. But since the speaker is somebody who was a former student, I thought I'd say a few words and also make this relevant. So, we started a program which was a pilot in 2009. Is that the year you? 2008, where we sent students for an entire semester to an international tribunal. And Nate was our guinea pig. He was the first person we ever sent as part of this program. And that program has grown, so today it is part of our capstone requirement, where every single one of our third years either takes the clinic or they go off and they work internationally or domestically for an entire semester. And that would never have happened if not for the tremendous success of Nate. So the hope of the capstone is often that when the students will go and they'll be placed somewhere for a long period of time, that they will impress the heck out of the employers and maybe get a job. But it's not so easy to get jobs in the world of international criminal tribunals, and particularly directly out of law school. In fact, I don't know anybody else in the world who has accomplished what Nate has. So Nate went from here to the Special Court for Sierra Leone for his internship. And as you'll hear in his bio, he's now been at 4 different tribunals working on the most important international criminal cases of our time. So you're in for a real treat when you're going to be hearing from him. And to hear more about his background, I present Professor Avadan Cover.
Good afternoon. I feel like Michael stole a little of my thunder here in terms of the bio. But, you know, I should note, actually, that tomorrow we have an all-day symposium honoring Fred Gray, who was an alumnus of this school from the class of 1954, for his contributions to civil rights law. He was involved as early as the Montgomery bus boycotts and played a critical role in the civil rights movement. Well, today we get to hear from incredibly young and distinguished alumnus who perhaps, I guess my math is right, you followed 55 years after Mr. Gray at this law school. And given what Nate Quick has done in such a short time, perhaps it will be even sooner that we will be honoring him for his contributions to international criminal law. Nate Quick's significant international criminal work experience began in earnest, as Michael mentioned, at an internship with the Special Court for Sierra Leone. Quick earned credit for his 6 months working there, where he helped build the case against former Liberian President Charles Taylor. He worked under the supervision of Jim Johnson, who is here as well. We're happy to have him. In 2013, the court convicted Taylor of 11 counts of war crimes and crimes against humanity, including terrorism, murder, and rape. And Taylor was sentenced to 50 years in prison in 2012. Between 2012 and 2014, Mr. Quick served as a legal advisor to the judges of the pretrial, trial, and Supreme Court chambers of the extraordinary chambers in the courts of Cambodia, which are tasked with trying serious crimes committed during the Khmer Rouge regime. Mr. Quick now serves as an attorney in chambers at the International Criminal Court in The Hague, where he provides legal research and advice to judges of the trial division. And most recently, and we'll hear a bit about this today, he worked on the case against Jean-Pierre Bemba Gombo, the leader of a militia movement in the Democratic Republic of the Congo, who was convicted in March 2016 of war crimes and crimes against humanity committed in the Central African Republic. Please join me in welcoming our very distinguished alumnus, Nate Quick. Thank you.
Good afternoon, everyone. I can get myself situated. You know, I really have a sense of deja vu being back in this room. 8 years ago, in this room, I was practicing for the National Moot Court team, being pestered with questions from Professor Bell and Professor Kupar. I also took classes and attended Cox Center lectures here. I remember listening to the judges of the Iraqi High Tribunal that tried Saddam Hussein, before and since other international law legends, such as Richard Goldstone, ICC Judge Christine Vanden Weingart, and my former boss, SCSL prosecutor Brenda J. Hollis, have stood at this lectern. So it is really humbling and a great honor to be here this afternoon to discuss with you my own experiences in international criminal law. You've already heard my international law resume and the great introduction that I received. This also roughly corresponds to the direction of my speech this afternoon. So to quickly recap, after case, I spent several years on the Charles Taylor prosecution team at the Special Court for Sierra Leone. I then moved to Cambodia, where I worked as a legal advisor to the judges at the extraordinary chambers in the courts of Cambodia. From there, I moved to the International Criminal Court, where I again worked as a legal advisor to the judges. Finally, as of next week, I will begin a new position on prosecution at the United Nations Mechanism for the International Criminal Tribunals. Just a brief disclaimer that any views I express here today are my own, despite the UN flag behind me. To start, I want to quote to you a few words from Carla Del Ponte, who was a long-serving prosecutor at the Tribunal for the former Yugoslavia. It captures the international criminal law experiment as I have also experienced it. And I quote, "The lessons to be drawn from the tribunal's successes and failures are valuable because these efforts were unprecedented. They took place along the edge of the divide between national sovereignty and international responsibility, in the gray zone between the judicial and political. It is a realm for which women and men engaged in international justice from Lebanon to Sierra Leone, from Rwanda to Congo, from Holland to Cambodia must now develop better maps and navigational instruments." Unquote. From my experience, there are 4 issues that I will discuss today in the context of my positions at the various courts that remain unresolved challenges for the international criminal law world. My purpose today is not to present solutions to these problems, but to speak about my interaction with them. First, there is the need to bring some level of justice to the victims. Second, there is the issue of contempt of courts. Third, there is an ongoing struggle to create a justice system, both in procedure and jurisprudence, which reflects the major legal systems of the world, but also addresses the unique circumstances of international criminal law. Finally, there is the challenge of downsizing and closing temporary tribunals, while also ensuring that their mandates can be fulfilled and their legacies maintained. In August 2008, as a third-year law student, Dean Scharf arranged for me a semester-long internship on prosecution at the Special Court for Sierra Leone, the SCSL. Just to give those who don't know a brief overview, the SCSL was set up in 2002 to address crimes, serious crimes against civilians and UN peacekeepers committed during the country's decade-long civil war. Over the course of its existence, 9 persons were convicted and sentenced to terms of imprisonment ranging from 15 to 52 years. As for the Taylor case, the last case at the SCSL, and the one I worked on, it gained a lot of attention from the press when Naomi Campbell and Mia Farrow testified about the blood diamonds Charles Taylor allegedly gave to Naomi Campbell. But the trial was about much more. The 11-count indictment against Charles Taylor charged him with responsibility for crimes against humanity, namely murder, rape, sexual slavery, other sexual violence, and other inhumane acts. War crimes, namely terrorism, unlawful killings, outrages upon personal dignity, and physical violence, and the enlistment or conscription or use of child soldiers. The trial lasted from 2007 to 2011. The judgment and sentence were both issued in 2012 and upheld by the appeals chamber. Charles Taylor was convicted of all counts and sentenced to 50 years imprisonment. After the final judgments in the Taylor case, the SCSL became the first international tribunal to transition to residual form, the Residual Special Court for Sierra Leone, which is staffed by about 12 persons with various officials and judges on call as needed. I will discuss a bit about residual mechanisms at the end of my speech today. I arrived for my internship on the Taylor prosecution team at the SCSL at the end of the judicial recess, before much of the office was back from vacation. But it wasn't long before the office became a flurry of activity. There were 10 lawyers, a case manager, and 2 interns working solely on Taylor. They came from the US, Australia, Scotland, Sierra Leone, Macedonia, England, Switzerland, and Trinidad. This trial team was assisted by a team of investigators, as well as various administrative personnel. At the time I arrived, the prosecution was in the midst of its case, which meant that all lawyers were otherwise disposed. To help fill the void, and in addition to the normal research and writing tasks of interns, I was soon assigned to sit with witnesses while they reviewed their statements. In between sessions, the witnesses and I would take breaks on the balcony of the interview location. They would complain about the cold, even when it was in the 70s and sunny. They would remark on the cityscape of The Hague, the number of bicycles, on the cleanliness and the number of trains coming and going from the station in the distance. There were some witnesses that really stuck with me, in particular, those who had been victimized and later became the victimizers. There was one evening that I went after court to meet with a witness named Edna Bangura. The lawyer assigned to her was scheduled to conduct witness proofing in preparation for her upcoming testimony the next day. I was there to go over her prior statements with her. As we went through these statements, she spoke shyly and quietly and in a sort of monotone. At age 10, she was abducted by the rebels. She was raped 3 times and then forced to carry goods on her head to a rebel camp. At the camp, she was forced to perform manual labor for a rebel commander named C.O. Scorpion and his wife. At 11, she was sent for military training and joined a military unit called the SGU, the Small Girl Unit. She learned how to use a gun, set an ambush, and retreat. From age 12, she was a victim of forced marriage and sexual slavery, referred to as a bushwife. Operation Pay Yourself during the Sierra Leone conflict resulted in the abduction, rape, sexual slavery, forced marriage of many civilian women. However, when considering Edna Bangor's story as a victim, you also have to consider her story as a victimizer. Her Small Girl Unit, SGU, went on food-finding missions during which they would raid civilians' homes, threaten them with guns, abuse them, take their food, and force them to carry it back to the base. They abused and enslaved civilians just as they themselves had been abused and enslaved. The rebels' acts were horrific. One protected prosecution witness saw the rebels kill her entire family. She was then forced to kill a bag containing human heads. The rebels ordered her to laugh while she carried the bag, which was dripping with blood. Later, the bag was emptied, and she saw the heads of her children. Unfortunately, there are striking similarities in other cases from wholly different regions and different time frames. To this end, I just want to briefly jump ahead in my experience and refer to evidence in a case I worked on recently at the ICC, the case against Jean-Pierre Bemba Gombo, who was convicted in March of crimes against humanity and war crimes committed by his forces during the 2002-2003 conflict in the Central African Republic. Like Operation Pay Yourself during the civil war in Sierra Leone, Bamba's soldiers self-compensated by acts of rape, a practice they innocuously termed Article 15. Several of the victim witnesses in the Bamba case came from a single family. The patriarch, his wife, their 3 daughters, their granddaughter, were all gang raped, beaten, all their belongings pillaged over the course of a single attack on their family compound. In some ways, the most disturbing testimony concerning this attack came from the patriarch himself. And I quote, "Prosecutor, I said earlier on that the whole family went through these atrocities. My 4 daughters had to go through this. One of them, I presume, will soon be right here. The second, the third, and the fourth, and the fifth, who is their mother. That means that all of them were raped. One of them, who was aged 11, also underwent the same fate. They didn't even feel any pity for that small girl. I think her case was the one that really upset me. As for those who were aged 15, 16, and 18, it could almost be tolerated. But as for the 11-year-old, I simply couldn't stand it. It was really terrible," unquote. This testimony demonstrates the impact of these atrocities on the culture and society, where it becomes the norm for women to be raped, and it becomes almost tolerated. This highlights the first topic of my speech today, the need for these courts to leave a legacy and have an impact, to reinforce the standards and norms as to what is acceptable and what is not, especially in times of war. In this regard, some suggest that one of the greatest challenges is indifference among the victimized population, which loses interest in lengthy proceedings, particularly when distracted by day-to-day concerns. In turn, some suggest that international justice's success must be measured against local impact, not just international effect. For example, the development of international law. In December 2008, I returned to the US to finish law school and take the bar. Immediately after, having managed to secure a position in The Hague at the Special Court for Sierra Leone, I returned. and the problems arising from holding a trial thousands of miles from the most affected population became even clearer. For security reasons, the court decided to hold the Charles Taylor trial in The Hague. 3 other trials concerning the leaders of the 3 key factions involved in the conflict in Sierra Leone were held in Freetown, the capital. Now a team of international prosecutors were trying a former Liberian president, represented by a British lawyer, before 3 international judges from Samoa, Northern Ireland, and Uganda, in Howland, thousands of miles from the crime sites. The distance from the Sierra Leone population could not be more pronounced. The court tried to ensure some transparency and impact among the population in Sierra Leone. The prosecutor and other court officials periodically covered the country, speaking to the local population and explaining the trial process. After closing submissions in the Taylor case, and while the judges were deliberating their judgments, I accompanied the prosecutor on one of these trips. I arrived at the airport. Oh, I should actually say that Jim Johnson actually accompanied me on this first trip. He took me the whole way, so I didn't expect that he would be here today. But I arrived at the airport, which was pure chaos. After showing my passport and landing permit, I was whisked off by security from the court that had come to meet us. They took us to a helicopter, one of the 2 ways to get to the city. My first African country, my first African airport, and my first helicopter ride in only a few hours. The next morning, we were in a Jeep bumping along up country. We were going first to Boidu, where the rebels had been based, and where there was a porous border with Liberia, through which Charles Taylor shipped so many weapons and troops, fueling the Sierra Leone conflict. Children poured out of every village and home we passed, excitedly waving at our convoy. We arrived in Boidu. The prosecutor proceeded, along with the court's public defender and spokesman, to explain as best she could the trial in The Hague and the fact that the judges were in the process of deciding whether or not Charles Taylor was guilty. Questions often revolved around the length of the proceedings and the result for the population. Some just wanted to be heard, to tell their stories and express their gratitude that someone was being held responsible, that their suffering was being acknowledged. Others wanted to know who would pay for prosthetics to replace amputated limbs. Who would care for the war orphans and the widows? Who would remedy the wrongs done to them? As expressed by witness Patrick Sharif in the Taylor case, the population above all else desired justice for the crimes committed against them. And I quote, "They cut off all 10 of my brother's fingers. When they finished, they took those 10 fingers and they said they would make a chain out of it. Oh, Father God, when they put the fingers in the cup, then they shot him. They shot him and he died on the spot, and they went. God will pay the promoters of these rebels in Sierra Leone. I am an innocent man. My brother was an innocent man. But now we are suffering. We suffered for nothing. God will bring judgment upon those who promoted the rebels." Unquote. From Boidu, we went to the mining center of Kenema, then to the other side of Sierra Leone on the border with Guinea, where similar outreach events were held. Soon after, back near Freetown, I was giving a speech to public prosecutors explaining cross-examination and training them in basic techniques. In the absence of a sufficient number of lawyers, the prosecutors for many lesser offenses were police officers. They therefore had little to no legal training. Such events were another means of ensuring a positive legacy for the court and a positive impact on the population. These outreach events, the interaction of the court officials with the local population, the training of police prosecutors and other professionals, the jurisprudence and legal databases created by the court, they were all efforts to ensure a lasting impact for the local population. But there's still a long way to go, and not just in relation to the physical distance. Do trials that last close to a decade and judgments that are thousands of pages long create a transparent and accessible process? Not long after my outreach trip to Sierra Leone, I took off to Cambodia to take up a new position for the United Nations assistance to the Khmer Rouge trials. In this role, I advised the judges at the Extraordinary Chambers in the Courts of Cambodia, the ECCC. I worked on various pretrial, trial, and appellate matters, devoting a year primarily to researching and drafting the first trial judgment in the case against the former head of state and deputy party secretary of the Khmer Rouge. This case involved the crimes against humanity connected to the forced mass evacuation of Phnom Penh, the Cambodian capital, later large-scale population movements from and between rural areas, and the executions at a location known as Tulpo Kre. In addition to the time I devoted to the above tasks, I also spent hours on the infamous commute to and from the court, sometimes as much as 3 or 4 hours each way. You know someone's an international criminal law insider, and Jacqueline Green knows well about this, if any conversation about that court begins with complaints about the 3 or 4 hour commutes. The rumor is that the UN officials that picked the location of the court were escorted by police in the dry season and avoided all traffic. They made it from the center of Phnom Penh to the military base in 15 minutes, but they did not take into account the fact that without a police escort, and especially during the rainy season, the buses provided by the court would be bogged down in traffic and flooding for hours each way. Anyways, back to the point. For those of you who, like me, were not even born in the 1970s, I'll provide you a brief background. The Khmer Rouge regime took power on April 17, 1975, and was overthrown on January 7, 1979. At least 1.7 million people are believed to have died from starvation, torture, execution, and forced labor during this period, which was followed by a civil war. That war finally ended in 1998 when the Khmer Rouge political and military structures were dismantled. In 1997, the government requested the United Nations to assist in establishing a trial to prosecute the senior leaders of the Khmer Rouge. In 2001, the Cambodian National Assembly passed a law to create a court to try serious crimes committed during the Khmer Rouge regime. Cambodia invited international participation due to the weakness of the Cambodian legal system and the international nature of the crimes, and to help in meeting international standards of justice. The ECCC has had many successes, including the trials and judgments against the former head of state, Khieu Samphan, and Deputy Party Secretary of the Khmer Rouge, Nun Chea, as well as Doik, the head of the most notorious security center, S21. Further, distance from the population was not a problem at the ECCC. Its location in Cambodia and its outreach efforts resulted in more than 150,000 people viewing the hearings in person, and hundreds of thousands of others attending outreach events. Nevertheless, these successes and the legacy of the court overall may be overshadowed by allegations of interference in cases 3 and 4. Such contempt of court and interference is the second topic of my speech today. On September 7th, 2009, the International Co-Prosecutor filed 2 introductory submissions requesting the co-investigating judges to initiate investigation of 5 suspected persons. These 2 submissions have been divided into what is known as case files 3 and 4. 2 individuals were initially named as suspects in case 3. In June 2015, the co-investigating judges issued a decision concluding the civil and criminal actions against one suspect, Sumet, the former Khmer Rouge Air Force commander, due to his death in 2014. A second suspect, Mi Smoot, the former Khmer Rouge Navy commander, was charged in absentia by the International Co-Investigating Judge in March 2015. He was notified of additional charges when he appeared before the International Co-Investigating Judge in December 2015. The charges against him include genocide, crimes against humanity, namely murder, extermination, enslavement, imprisonment, torture, persecution, other inhumane acts, and war crimes, namely willful killing, willfully causing great suffering or serious injury to body or health, torture, and unlawful confinement of civilians. These crimes were allegedly committed at various security centers, work sites, districts, execution sites, and cooperatives throughout Cambodia. As for Case 4, it is currently under investigation by the co-investigating judges, and the identity of the suspects remains confidential. When I arrived at the ECCC in April 2012, it was in the midst of a deadlock between the international and Cambodian judges investigating Cases 3 and 4. Prime Minister Hun Sen had opposed the investigation of these cases. He claimed that it exceeded the limits of the court's jurisdiction, resulted in Khmer Rouge fleeing back to the jungle, and risked civil war. Whether connected to the clear opposition of the governments or not, the Cambodian judges and officials at the court refused to take part in the investigation. It was in this situation that the divide between the judicial and political was truly blurred. Being based on French procedural law, the investigations are judicially conducted by investigating judges, not by prosecutors like in the US and other international courts such as the SCSL I discussed before. These judges are obliged to investigate any crimes submitted to them for investigation. It was therefore essential to the court's, or all the more essential, to the court's reputation and its legitimacy overall, that the investigations in Cases 3 and 4 be resolved in a legal manner. In this regard, it became the role of many international staff and judges to use their diplomatic skills and attempt to secure cooperation in these investigations. Along with the appearance of bias from the government's pronouncements came the funding crisis for the national side. Due to the controversy, international donors limited their assistance to the international side of the court. For months at a time, national staff and judges were unpaid. The court's appearance and impartiality was seriously under attack. The lack of cooperation between Cambodians and internationals also signaled in many ways the breakdown of the capacity of building intended by the UN's involvement. The Cambodian judges and staff were supposed to learn from the internationals' experience, their technology, their drafting and research, their example. This relationship was severely strained. Despite these problems, the investigations in Cases 3 and 4 have progressed. For example, notice of the conclusion of the judicial investigation against Im Cham, a Khmer Rouge district commander, was issued on December 18, 2015, and final submissions are ongoing. As noted by International Investigating Judge Casper Anserme in his letter of resignation not long after my arrival at the ECCC, it remains necessary for the authorities of the governments and United Nations to take a clear and common stand concerning the future of Cases 3 and 4, so as to restore the image and dignity of the ECCC and uphold international justice. After 2.5 years in Cambodia, I was ready to head west again. In August 2014, I started working as a legal officer in the trial division of chambers at the International Criminal Court, the only permanent international court. My role, just as at the ECCC, was to advise the judges, as well as to research and draft their opinions, decisions, and judgments. When I arrived, there were many cases at various stages before the trial division of chambers. I was initially assigned as what was termed as a floater. I would float between cases, drafting decisions, conducting research, and advising the judges on most cases pending at the time, including the cases against the former president of Ivory Coast, the current president and vice president of Kenya, and Senator Jean-Pierre Bamba Gombo of the Democratic Republic of Congo, who, as I mentioned before, was convicted in March of crimes against humanity and war crimes committed by his forces during the 2002-2003 conflict in the Central African Republic. Indeed, I devoted much of my time at the ICC to the judgment and sentence against Jean-Pierre Bamba Gombo. I'll give you a brief background of the ICC. It was created by the Rome Statute, adopted on July 17, 1998. In 2003, the first judges were sworn in, and the first arrest warrants were issued in 2005. There are 124 member states, unfortunately not including the United States. The court's pretrial chambers have publicly indicted 39 people. Proceedings against 14 have been completed, including 3 convictions and 1 acquittal. Trial and appeal proceedings are ongoing in 6 cases against 11 accused. Victims' reparation proceedings are ongoing in 4 cases. With so much ongoing at the court and throughout the world, with non-cooperative governments, with staff and judges from diverse legal systems, with victims and witnesses with very real security concerns, and in the absence of a police force or disciplinary bodies like legal associations, prosecution of contempt of court is key to the ICC's success, just as it has been for all international tribunals thus far. As with international crimes, there's a struggle to try contempt cases efficiently and justly so as to ensure the greatest impact. Last month, I concluded my work in chambers at the International Criminal Court, assisting in the first contempt case at that court. The judgment is expected next week on October 19th. It's a fascinating case insofar as much of the evidence against the 5 accused is comprised of intercepted telephone conversations. The prosecution alleged that between 2011 and 2014, the 5 defendants were responsible for bribing witnesses in the Bamba case with cash and via money transfers, making non-monetary promises or inducements to witnesses, such as the possibility of relocating abroad and benefiting from Mr. Bamba's protection, and instructing witnesses on what to say when questioned in court, including scripting their evidence, dictating and rehearsing false answers. At least 14 out of the 34 witnesses for the defense in the Bamba case were allegedly subject to such interference. This included several witnesses who, according to the prosecution, were given entire backstories to relate and instructed to testify that they were officers in various military factions, even though they had no such military background. They were supposedly briefed by others who did have such military background and were given all details relevant to their new personas. The prosecution claims that when the defendants eventually became aware of an investigation into their witness interference, they again contacted the same witnesses and again bribed them so that they would not, and I quote, lose all the work they had done so far, unquote. I will refrain from commenting further as the judgment is pending. And this is just one, possibly the best recorded, example of alleged witness interference on the part of members of the defense, prosecution, journalists, or others, which have posed major problems for all international courts. The appeals chamber of the Tribunal for the former Yugoslavia has put the danger of contempt quite simply and clearly in relation to the court's ability to obtain witnesses, secure state cooperation, and ensure the integrity of the proceedings and the reliability of the evidence. And I quote, "It is justice itself which is flouted by contempt of courts," unquote. I just want to touch quickly upon my third topic, namely the interaction between legal traditions, in particular common law systems like the US that are largely party-driven, as derived from the English tradition, and those civil law systems that are much more judge-driven, as derived from continental European traditions. At the ICC, while there are some pronouncements and compromises apparent in the Rome Statute itself, for example, victim participation, a feature primarily reflective of civil law, the statute is silent and ambiguous on many other matters, in particular, procedural issues where there are differences between common law and civil law systems. Accordingly, there was much that the drafters left to the judges to decide upon as regards the procedure to be followed. Here, I want to note a conversation at a dinner last month in honor of my departure from the ICC. A judge told me how exciting it was that there's so much at the court still to be created, to be invented, to be experimented with. He noted that in national jurisdictions, it's often only legal tweaking that's left to the judges after hundreds or thousands of years of legal development. While it is indeed exciting, the largely uncharted international procedure, open to interpretation and experimentation, has led to some points of contention, with different judges taking different approaches. For example, the admissibility of evidence and pre-testimony witness preparation. I will briefly touch upon these topics. In American courts, and indeed legal education, the rules of evidence are very important and in many ways form the backbone of the criminal process, from the investigation phase to the appellate phase. However, at the international courts, there are no juries, which has led to the debate as to whether rules of evidence remain necessary. For example, hearsay evidence in all its forms is generally admissible. The idea is that professional judges are able to assign it appropriate weight in a manner that juries are incapable of. It was long the rule that the admissibility bar was low at the international courts. Evidence was admissible so long as it was prima facie relevant and reliable. However, now there are chambers at the ICC composed of both common law and civil law judges that, as a general rule, do not decide on the admissibility of evidence during the trial. This derives from the civil law system, where everything on the case record, that is, everything collected during the investigation, is automatically before the judges at trial and can be considered for guilt. The decisions implementing this procedure at the ICC stress the absence of the jury and the time and resources spent ruling on the admissibility of each piece of evidence over the course of the trial. Notably, many of the parties in the cases which are subject to this new procedural regime have opposed it, requesting that the chamber rule on the admissibility of evidence as it is presented. Likewise, there are also judges from both common law and civil law countries who disagree with this new approach. They see admissibility decisions as a necessary component of a fair and expeditious trial, notifying the parties of what may be considered in the judgment, excluding evidence which has no probative value or is unduly prejudicial, and permitting the judges to manage the evidence presented. I will not further engage with this debate which continues before the ICC, but note that it could be an interesting topic for eager international law students here at CASE. Another potential thesis topic would be the practice of witness preparation or proofing before the international courts. At the ICC, just as with admissibility decisions, meetings between counsel and a witness to prepare that witness for his or her testimony do not exist in the civil law system, because usually the investigations are conducted by an impartial authority and the witnesses are called by the judges, not the parties. Judges from civil law systems therefore see witness preparation as something that impedes their truth-seeking function, risking the spontaneity and reliability of the witness's testimony. On the other hand, in some common law systems, including many American jurisdictions, the failure to meet a witness before calling him or her may constitute professional misconduct. The tension between the systems is therefore clear. At the ICC, the majority of chambers have not allowed witness preparation by the parties. However, it has been permitted, subject to various safeguards and protocols, in 3 cases. Again, I will not comment further as this debate continues at the ICC, but I just wanted to note this example, which clearly demonstrates the tension between different legal traditions. Certainly, this poses a challenge to the international courts to distill a procedure that is fair and expeditious, drawing from all traditions. Finally, my last topic is the closure of the temporary tribunals. It is a very current and ongoing issue in international law, as the ICC is the only permanent court. The courts have limited mandate for crimes committed during certain time periods in the former Yugoslavia, Rwanda, Sierra Leone, Kosovo, Lebanon, and Cambodia eventually must close down once their mandates are complete. However, many of the court's essential functions are ongoing. They do not end with a final judgment in a final case. In order to ensure that such ongoing functions, such as the protection of witnesses, supervision of sentences, and preservation of archives are fulfilled, it is necessary to transfer such functions to another court, extend the lifespan of the existing court, or set up a residual mechanism. In relation to the SCSL and the tribunals for Rwanda and the former Yugoslavia, residual mechanisms were chosen. Such mechanisms were intended to be smaller, leaner, more efficient bodies which could handle all ongoing functions of the courts. In the words of President Morone of the United Nations Mechanism for the International Criminal Tribunals, which is known as the MICT, creation of such mechanisms is necessary, and I quote, to guarantee that the closure of the ad hoc tribunals does not open the way for impunity to reign once more, unquote. The need for residual mechanisms or adequate closure strategies was highlighted by the manner in which the special panels for serious crimes in East Timor were closed in 2005. A strict cutoff date was set for the conclusion of all trials, regardless of their stage. Further, an agreement between the government and the UN concerning the court's archives took more than a year to complete. During this time, government offices were looted and the court's databases and records taken. My first interaction with the residual courts and functions was at the SCSL, where I played a role in early preparations within the Office of the Prosecutor for transition to residual form. I drafted and researched various protocols concerning archives, in particular of confidential and sensitive information. But I want to focus briefly on the MICT, where I will begin my new position on prosecution next week. The MICT was established by the United Nations Security Council on December 20th, 2010 to carry out a number of essential functions of the tribunals for Rwanda and the former Yugoslavia after the completion of their respective mandates. Securing the arrest, transfer, and prosecution of the 8 remaining fugitives still wanted for trial by the Rwanda Tribunal is a top priority for the mechanism. Of these, the MICT maintains jurisdiction over the cases against 3 of these fugitives, including the former Rwandan Minister of Defense, Augustin Bizimana, and Felicien Kabuga, a Rwandan businessman accused of participating in and bankrolling the Rwandan genocide. The cases against the other fugitives were transferred to Rwanda for trial in case of their arrest. Other functions of the mechanism include pending appeals proceedings, retrials, trials for contempt of court and false testimony, protection of victims and witnesses, and supervision of enforcement of sentences. Generally, the downsizing and closure of international courts is a current and key issue in international criminal law, which I'm sure I will shortly have plenty of experience with. In relation to the mandate of the MICT, I highlight the possibility of a retrial, where the court of first instance enters an acquittal, which is an interesting feature of the international criminal courts, which is also at odds with the prohibition against double jeopardy as it exists and is applied in many common law jurisdictions, including the US. Currently, at the MICT, the retrial in the Stanisic and Smotovich case is underway. As it's a very interesting procedure, just a brief summary. The trial against Jovika Stanisic and Franko Smotovich lasted from June 9th, 2009, until January 31st, 2013. On May 30th, 2013, Trial Chamber 1, by majority, acquitted Stanisic and Smotovich on all counts of the indictments. Following the prosecution's appeal, the appeals chamber on December 15th, 2015, granted in part the appeal and quashed the acquittals. The appeals chamber, by majority, found that the trial chamber erroneously failed to adjudicate and provide a reasoned opinion on essential elements of the charged mode of liability. The appeals chamber ordered that Stanisic and Smotovich be retried on all counts of the indictment. This trial is currently ongoing. Yet another topic for eager international law students. That brings me to the end of my lecture. In the words of Carla Del Ponte, the former prosecutor at the Tribunal for the former Yugoslavia, that I quoted at the beginning of this speech, the international community and those working in international criminal law must develop better maps and navigational instruments to ensure the success and efficacy of international criminal justice. Thank you for coming this afternoon. Thanks again to Dean Scharf and the Cox Center for having me.
Thank you so much, Nate. We have almost 15 minutes allotted for questions, so would love to hear from audience members. Any questions? Any students here? Questions? You want a little job advice? Maybe Nate can offer some as well. Here we go. We have a microphone, or we're not worried about it. All right, great.
I can give up. So when you were a student at Case, what classes do you think best prepared you for basically your work within the various international institutions?
Well, I think the obvious answer is the international law classes that Jim Johnson, Professor Scharf teach. I mean, it's key to sort of have some sort of insight into how these tribunals work and, you know, the unique procedure and jurisprudence that they apply and how they are deriving sort of this international criminal law and how they are figuring it out. So that's definitely necessary, but otherwise, I mean, the writing and research classes at Case, the legal reasoning, it's all applicable and relevant, of course. Except for maybe not in the future, the evidence class, I guess, but yeah.
To piggyback off of that, like aside from your, I guess like the courses that we take, what other ways would you suggest students kind of set themselves apart to get jobs and internships in such a competitive field?
I think for American law students, one key way to set yourself apart is to learn French. Definitely, because it's one of two languages, working languages for most of the courts. I would say that the majority of Americans working at the courts do not speak French. So it definitely would set yourself apart from other American applicants. Otherwise, I mean, taking or doing as many internships as you can and just getting as much experience as you can and being in the right place at the right time. Yeah. Yep. On paper, I do. Yeah.
So a lot of the challenges that you were discussing,
Yeah.
are a lot of these being resolved obviously within the court, but outside of within the courts, I guess from a political standpoint within countries that are members or countries that are participating in these, what influence do they have on it, or what can be done within countries to kind of advocate for or champion changes and kind of resolutions to some of these challenges?
Well, I think the ECCC is a very good example. I mean, it was key that the international donors, at some points, I think, attaching restrictions on their funding, but it was necessary for them to provide funds to the national side as well as the international side of the court. So I think that the donors, the international community, obviously have a lot of influence on the administration of the courts, I would say. But at the same time, it's necessary for these courts, especially where the divide between the political and the judicial is so unclear, that the judicial process, the prosecutorial discretion is divorced as much as possible from the donors and the international community. So
So it's best to let them resolve it
within the institution, right?
Actually come in and start to
Definitely, yeah.
What do you think the success of the goal of capacity building for local, members of the legal community has been through these various courts and your experience in the different courts?
I think that the Special Court for Sierra Leone and the extraordinary chambers in the courts of Cambodia have definitely had an impact on the professionals working in those legal systems. I mean, just having the internationals and the UN there, to a certain extent, sets an example. And I mean, there's definitely sharing, and you learn as much from the Cambodians and from the Sierra Leoneans as they learn from you. But I mean, just seeing day to day, especially how a modern and technologically advanced court can function, if it's functioning at its best, is the biggest success in capacity building in those countries and in those courts, I think.
I think the skills training is adequate for local lawyers. Could there be more of that?
I think there could be more of that. I think there's There's also sort of tension between exactly what the mandates of the courts are, though, as well. I mean, the mandate of the court is to try international crimes and to see that the process is, concluded. And it is important to have the local impact, as I stressed throughout, but to what extent the resources of the court can be or should be expended on training local attorneys and everything else is, it's up for debate. So as much as possible, for sure, but yeah. Yep.
Might be a little bit outside your scope, but
Yeah.
recently Congress passed a law that allowed the U.S. to sue Saudi Arabia for acts of terrorism.
Yep.
Do you see how that will play out down the road?
Yeah, I really, I have no opinion that I can express, I don't think, but I mean, it's very interesting, and I'm sure here at CASE it will be definitely debated and discussed, but nothing for me. Sorry.
What do you say to the criticism of many international criminal courts that it is sort of an elite, often even racialized form of justice, where so many of those who are tried and sentenced are in particular from African countries, but certainly underdeveloped nations, and sort of something emanating from The Hague and international wealthier countries?
Yeah, I mean, those are criticisms that continue, and I think they've affected every single one of the international courts. But a little bit of a focus on legacy and impact on the population goes a long way with that. Also, the idea that these courts were created with mandates to try crimes in these countries and to address atrocities that were not being addressed in these domestic jurisdictions. I mean, I wouldn't say that it's necessarily, or it's not racially motivated or anything else. There's no targeting of African countries, really. If anything, it's paying attention to the problems in African countries and seeking to get some level of justice for atrocities that there would otherwise be nothing for. So. Yeah.
You mentioned a couple of cases in Cambodia where the defendants were not publicly named. How did that arrangement come about?
It's the unique system, which is based on French procedural law. If you compare it to when investigations are being conducted in the US by the prosecutor or by the police, often the investigations progress, the suspects aren't names, they aren't public. So it's a similar thing. Like there's no prosecutor's investigation. These are investigating judges who are investigating it themselves. So at some point in time, they have to notify the suspects of the charges against them. But until that time, until they identify suspects, until they decide on charging and everything else, they can keep the suspects' identities confidential. Yeah.
Briefly, you mentioned the prosecution of the present Kenyan president.
Yeah.
Kenya being an ally of the U.S. Can you touch on that a little further?
Yeah, I mean, the Kenyan cases concerned the post-election violence. I'm having to reach into my memory, but basically these cases were highly politicized at the ICC. They gained a lot of press and attention due to the Kenyan government's alleged interference in these cases as well. Both have now concluded. One case concluded due to a lack of, or both cases actually concluded due to a lack of evidence. One was concluded by judicial decision, and the other case, the prosecutor withdrew the charges. And I believe the prosecution's position is that this is due to non-cooperation by the Kenyan government.
Since you've had this opportunity to work at a court that was
really within the country where the atrocities happen versus working through the ICC in The Hague. How would you say that distance impacts the actual process of justice within the courts?
I mean, the impact is huge as far as it impacts on, you know, like when the court is located in The Hague and all your witnesses are coming from Sierra Leone or Rwanda or somewhere else, there are the practical difficulties of transporting those witnesses, especially when they are protected witnesses and keeping their identities confidential. So there are those types of difficulties. There are also the difficulties of trying to ensure that the local population is able to follow the proceedings. This could be by outreach events, like I discussed, or I believe all the courts now have real-time, well, not exactly real-time, they're delayed by 5 or 15 minutes, 30 minutes, delayed by 30 minutes, where it's broadcast on the internet, so you can watch every day of the trial live, as long as it's public session. So I mean, like, there are these issues. And then there's also the issues of trying to address like individual victims or victim group concerns, which is a huge issue in international criminal law now. The earlier tribunals, such as the SCSL and Rwanda and former Yugoslavia, did not include anything relating to victims' reparations. Cambodia, STL, the Lebanon court, and the ICC now include procedures which actually allow for individual and collective reparations. So that also allows for a greater impact and a greater individualized targeting of the justice system. Yep.
Time for one more question.
I mean, I could comment a lot, but I wouldn't necessarily say that there's a conflict between the Cambodian and international judges as much as there is a clear difference of opinion. There's no evidence of that I'm aware of that the national judges are actually acting in light of the government's position. It just matches up. But I mean, as far as, you know, their working relationship and deliberations and everything, that's confidential. But I mean, it's not necessarily an ongoing like conflict or battle between these judges. It's sort of just a more difference of opinion. They issue opinions saying, we don't want these investigations to continue. The internationals issue opinions continuing the investigation. So. Yep.
Please join me in thanking Nate Swick. We have, in case you don't have your class of 2009 sweatshirt, we have some swag for you. Please join us outside in the atrium for a bit of refreshment and perhaps further opportunity to talk with Nate then. Thank you very much.
Thank you.
You said you had Finley and a couple of professors who went to
Yes.